Today, I want to hop back into the testimony of Terrence Bradley, who really has become a star witness in this case, and it is so messy, y'all. I think it's messy because, number one, Terrence Bradley was a kikiing, gossiping about the relationship between Fani Willis and Nathan Wade to Merchant, who later on ended up filing a motion. Now, apparently what happened was Terrence Bradley, when he was a kikiing back and forth with Elizabeth Merchant, she was saying things like, oh, I'm going to try to keep you safe. I'm not going to include you in the motion, da, 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 da. But at some point down the line, she realized that she had to include him in this motion. It wasn't going to sound right, and it wasn't going to be believable if she didn't include him in the motion. So then she subpoenaed him to testify. He fought the subpoena, and everything went left. All that to say this really all started based on a whiff of a rumor that the defense attorney heard. Now we're in court testifying under oath. And when you're under oath, you need to be telling the truth, the whole truth, and nothing but the truth, honey. And I think there's been some things that I've been hearing. I have some question marks. People either are hiding the ball, they're either dodging questions or not saying, exactly what needs to be said, or they don't want to give you the whole truth. They want to give you partial truth. So I don't know. I mean, what do you guys think? Ultimately, though, it's going to be up to the judge in this case to judge the credibility of the witnesses. But I do want to hop into Terrence Bradley's testimony because, as I said earlier, I do believe he's become the star witness of this case. Without further ado, let's hop right into it. I had my glasses on because I'm blind.
That's when you should get to the court for the truth, nothing but the truth to help you.
I do.
Please be seated. First and last name for the court.
Terrence Bradley, Terrence Bradley, Bradley. Ms. Merchant.
Thank you, Judge. Good afternoon, Mr. Bradley.
Good afternoon.
Good to see you. Sorry, under these circumstances. I'm going to just go straight to where we left off before. Fani Willis and Nathan Wade were in a romantic relationship, correct?
Correct.
Right.
And
hopping right into it.
It began at the time that they were both municipal court judges, correct?
Objection, Your Honor, it's based on privilege. That was covered in the attorney.
Okay, overruled.
So they're still objecting to privilege, and I think that's interesting because the judge has already made a determination that Terrence Bradley can testify, and that whatever privilege he was asserting, attorney-client privilege he was asserting. So, for example, if he was asserting that he learned things about the relationship between Fani Willis and Nathan Wade because of his status as the divorce attorney. Terrence Bradley, this attorney, if you don't know, was Nathan Wade's divorce attorney. And essentially his argument was that he learned certain things about the relationship throughout representing the client, Nathan Wade. But the judge has already decided that this information that he learned was not privilege. It was not through, his representation of Nathan Wade. It was not solely because of that representation. These are things that he knew outside of that, is what I understand. But the judge has already determined that information, the information about the relationship that Terrence Bradley is going to be testifying about today, it's not privileged. So I am surprised to still see the prosecutors objecting to privilege, but perhaps they just want to get it on the record. However, the judge has already determined that this is not privileged, and so those objections are going to be overruled.
I do not have knowledge of it starting or when it started.
Terrence, you told me that it started when they were both municipal court judges, though, correct?
That is incorrect.
This is so unusual because you've got these two past friends on the stand rehashing a conversation that Elizabeth Merchant, or Miss Merchant, let me just call her Miss Merchant. Miss Merchant says that they had a conversation. I don't know if Miss Merchant is talking about text message. I don't know if she's talking about they talked on the phone. I don't know if she's saying they talked in person. But you've got these two attorneys who used to be friends going back and forth about, didn't you tell me this? No, I didn't tell you that. Okay, well, you did tell me this, right? And so obviously Terrence Bradley is an attorney, an extremely skilled attorney. Miss Merchant, the defense attorney, called Mr. Bradley one of the best attorneys that she's ever met, that she's ever known. So obviously he's going to be highly skilled on the stand, and he's not going to answer any questions that are going to implicate him or implicate anybody else, is what it sounds like. He's not going to be easily tripped up or trapped by any of these questions, though I don't think the defense attorney is asking particularly sneaky questions. I think she's just asking, didn't you tell me this? And he's going to say yes or no. And obviously from her standpoint, he did tell her that, but he's saying, whatever you think you heard, you ain't hear that.
Correct.
You never confirmed in writing that it was, instead of magistrate court, it was in municipal court when they started dating?
If you're speaking of the text message, you can go to that text message and you can read that text message, and I will explain the text message to you. But you and I did not have a conversation about when it started. You asked a compound question of magistrate court versus, you said it was magistrate court, you said magistrate court conference. I'm sorry. And then you asked another question. I said, no, municipal court, nothing else.
I'm referring to a different conversation. I asked you, do you think it started before she hired him?
Your Honor, I'm going to object. This was covered in the previous hearing where Mr. Bradley said he had no personal knowledge of the exact text that Ms. Merchant is speaking of and actually used in an attempt to refresh his recollection. And he explained exactly what he's explaining here before the court. So this is repetitive and unnecessary. And so I would object to asked and answered and relevance at this point.
All right, perhaps we'll get there, but I think first Ms. Merchant has the right to draw his attention.
So where we're at here is there was this text message that Merchant sent Bradley, and she basically was like, oh, did the relationship start at this X conference? Say, for example, magistrate court conference. And he said, no, municipal. So what he's trying to say is his version of that was, no, I wasn't saying when it started. I was saying that they met at a municipal conference, not a magistrate judge conference. But she took that text message to mean the relationship started at that conference or before that conference, whatever. You see what I'm saying? So that's kind of the debate here.
And relevance at this point.
All right, perhaps we'll get there, but I think first Ms. Merchant has the right to draw his attention to the exact potentially inconsistent statement.
Thank you, Judge. May I approach him?
It's overruled. You may.
Oh, you can see it. It's the ones I gave you at the last hearing.
And for purposes of the record, I believe Ms. Merchant, you tendered, was it the entire text chain as an exhibit?
I only tendered a few of the texts, but I did give the state their courtesy copies last time of the exhibits.
Was this one tendered?
This one was not tendered.
All right.
And I'm happy to tender it.
We'll just take it as it comes, whatever you.
We're at, I think we're at 39. I will wait to mark it, but I think we're at 39. May I approach, Judge?
May.
All right. So Terrence, do you remember telling me that it started when she left the DA's office and was a judge in South Fulton?
I see the message there, but I don't recall. I do see that message, but I do not recall.
You don't recall texting this?
I look back at my text messages through that we've had. I see that message, but I do not recall that. No, ma'am.
And when I asked you if you thought it started before she hired him, and you responded absolutely.
Your Honor, I'm going to object as to the source of the information that Mr. Bradley allegedly gathered this from. There's been absolutely no foundation, and based on the arguments at the last hearing, that a lot of this is based on gossip, innuendo, assumption, and privileged information. And at this point, Ms. Merchant has not provided a foundation as to how Mr. Bradley would have any information that she keeps referring to.
All right, I think
Judge,
that's, go ahead, Ms. Merchant.
I didn't ask him about the source of the information. And under Rule 621, I can impeach him with any inconsistent facts. This is an inconsistent fact. I can impeach him with any contrary facts.
Sure.
This is a
Why would it
contrary
be
fact.
a relevant impeachment if he actually has no personal knowledge of this?
If he doesn't.
Sure.
have
So
personal
I think you have to lay that foundation then, so that'll be sustained.
So, right. So here the defense attorney is asking Mr. Bradley, essentially, when do you think this relationship started? And he's saying, oh, I definitely think it started, before she hired him, whatever. Okay, you think it, you don't know though, right? He has no personal knowledge. He said repeatedly, he doesn't know exactly when it started. He didn't see them together. He didn't see them doing anything romantic, right? Prior. I don't know if he ever did, but certainly not prior to him being hired, right? To Nathan Wade being hired. So essentially what he's saying here is, when I said absolutely, I'm going off gossip. I'm going off things I heard. I don't have any foundation to lay to say that I have direct personal knowledge. When I texted you absolutely, what I'm saying, that might have been from a rumor. I don't know what it was from, but Terrence Bradley is essentially saying that he doesn't have any personal knowledge of this relationship. So whatever he was texting her was gossip, hearsay, just stuff that he heard, around the way. And to that extent, the objection that was made by the prosecutor there is going to be sustained.
Do you remember telling me that it began?
Well, that doesn't address the issue.
No, I'm not. I was just asking if you remember telling me as opposed to the
Okay,
text.
sure.
Do you remember telling me that it began?
Well, no, and then you're going into the substance of it, which we haven't determined whether he actually knows or how he knows.
in these cases, you're always going to be trying to avoid hearsay, right? And the defense attorney, Ms. Merchant here, is trying to get around that hearsay objection because, again, she's going to have to establish that Mr. Bradley has some sort of direct knowledge or that she has some sort of hearsay exception where he can talk about how he knew the relationship began prior to Nathan Wade being hired by Fani Willis. But in this case, it just doesn't sound like he has any direct knowledge. No one has said he has direct knowledge. She is saying he told her that the relationship started beforehand, but she can't prove how he knew that, if he heard it from somebody else or not. So I think we're kind of going spinning in circles on this particular point.
You told me, in fact, you corrected me when I said magistrate court. You corrected me and said it was municipal court. Do you
Yeah.
remember that?
Same objection, Your Honor.
This is the exact same issue, right?
Well, I'm
Yeah,
asking if he remembers that. He hasn't answered that question yet.
right, but the relevance of whether he remembers it isn't established until we know how he remembers it or why he knows it. If that makes sense. I guess not.
Sorry, how he knows it. I'm just asking if he told me that.
Right.
So I wasn't asking how he knew that. I wasn't asking the source of that knowledge. I was asking if he told me that. That
Sure.
was it.
But that's the point. It's how he knows it.
Right.
The source of his knowledge, the state would contend is hearsay because it's gossip and innuendo, which is what was indicated the last hearing.
Well, it may not be hearsay. It may not be gossip. We haven't really gotten there yet. We don't know how he knows what apparently he's telling her. And I think we need to figure that out before we can go any further.
Yes. And if the source of the information is a witness who've testified, then it's not hearsay. So when did the relationship start?
I cannot answer that.
When was your first knowledge of the relationship?
Objection, Your Honor. He's already answered that question multiple times today. He said he has no idea the timeline or when it occurred. That was one of the first questions that Ms. Merchant asked.
I didn't ask when. I asked his first knowledge. He testified he has knowledge that they had a relationship. I asked him when he first.
Yeah, I mean, I think that's a fair question actually by the defense attorney. When is his first knowledge? When did he first have knowledge that there was a relationship? I mean, that's different from when did the relationship start? So I do think she should be able to ask that question and he should be able to answer it, though I don't know if he's going to give a direct answer or if he even remembers when he first had knowledge of the relationship.
Just got knowledge of that.
Okay. So if the question is, when did you first get knowledge? I think we can start there.
That was the question. Yes.
All right.
Thank you. When did you first get knowledge of their relationship?
I've said over again that I didn't have any personal information where I could personally say when it started. I've said that time and time again. So I don't know when the relationship started.
And that wasn't my question. So my question is, when did you first gain knowledge? I didn't ask the source of the knowledge, didn't ask you to comment on the validity of the knowledge. I asked when you first had knowledge.
We'll get to the how, Mr. Abadi. So I'll note the objection, overrule it. You can answer that.
And just for the record, and I appreciate Your Honor. But he said he had no personal knowledge, so he had to gain the knowledge from hearsay.
He could have gained it from
Sure.
Mr. Wade.
Well, I mean, most of us learn things from hearsay. The question of whether it's admissible, right? And that's what we got to get to. So
I apologize.
Yeah, I mean, she asked your first knowledge. He answered, when did the relationship first start? But she said, when is your first knowledge? So, I mean, he can easily just say, I don't remember, because he probably doesn't remember if his first knowledge was, you know what I'm saying, 8 months ago. I mean, who knows? I don't know how when I first was aware that, you know, my friend was dating somebody else. I don't.
When did you first get knowledge? I'm not qualifying what type of knowledge. I'm just asking when you first knew about the relationship.
I don't know how to answer that. I mean, so I can't give you a date if you're asking for a date. If you're asking me, how did I get the knowledge? It would have come directly from a client.
Right.
So help me understand.
I think you say you can't answer that question. You don't know the date. So that's the answer to the question.
But I said that 5 minutes ago.
We have to make it clear.
Yes,
All
sir.
right. Next question, Ms. Merchant.
So you don't know the specific date.
No.
Do you know if can we narrow down the timeline? Did you gain knowledge in 2019 of this relationship beginning?
I'm going to object to this line of questioning as he said he does not know
Sure.
when he gained
All right.
knowledge.
He doesn't know the
Overrule-
specific
That's
date.
fine, Ms. Merchant. I'm overruling that. I think we can try to see if he can narrow it down based on goalposts?
Thank you.
19, I would probably say no. I mean, I don't have anything that there wasn't a specific date. There wasn't a football game. There wasn't something that I can attribute to him telling me whatever. And so you're asking for a date, you're asking for a year, it's still a date. And at this time, I am telling you that I do not have the date.
Let's try this then. So you received a contract from Ms. Willis, January 2021, correct?
Can I see the,
Yes,
yes, I think so.
Exhibits are, I think, okay.
I think
It-
if it was from the exhibits, I think it was 21, yes.
And I don't want to belabor the point, because of those
Yes.
when you were here before.
Yes,
If those documents that you looked at last time,
yes,
it's like January 2022, that's, okay.
21. I
I'm
didn't,
sorry, 21, you're right, thank
and
you.
it was, I think, renewed in 22.
It was, yes. So the contract date was, that we have in the record is January 25th, 2022. So using that date, at that point, had they begun their romantic relationship?
Of 2022,
January 25th, 2022, 2021, I'm sorry. When you got your first contract?
I don't recall.
Yeah, I mean, the answer is going to be I don't remember, I don't recall, I don't know, right? I mean, there's no way he's going to be like, yeah, they definitely were in a relationship before he got hired in 2019 and da da da. I mean, he's probably going to keep saying, I don't know, I don't remember, I don't have a date. And so I understand the defense attorney has to get her questions off. I know she's going to try to kind of box him in, try to narrow it down. I don't know that she's going to be able to successfully do that. He's obviously said, I don't know. And that's the answer. If you don't know, you don't know.
I don't recall any specific dates. No, ma'am.
You remember when you got that contract, though, correct?
I remember I had the contract, yes.
Okay. And you told us last week, or I guess it was a week before now, you told us that Mr. Wade brought you that contract, essentially told you about that contract.
That is correct.
So Ms. Willis is not the one that brought that contract to you directly. It was Mr. Wade.
That is correct.
At that point in time, they were already engaged in a relationship, though,
I'm going
correct?
to object, Your
I
Honor.
can't say that.
Characterization of what Mr. Bradley just said. He just said he does not remember. There's nothing
He
specific.
doesn't remember the exact date. I think the question now is to reference it or tie it to maybe some other event that he might remember.
I agree with Your Honor. She asked that specific question. He said he does not remember any specific dates after signing the contract. That's exactly
Sure.
what he just said. This is
All
asked and answered.
I know, and we're getting to the end of it. So, Ms. Merchant, you don't have much more to pull on here, but
I keep wanting to like speed it up, but then Miss Merchant talks so fast that it's like triple speed. So sorry y'all for that.
he answered that last question. So what's your next one?
And Judge, I didn't hear the answer if they were in a relationship January 25th,
Mr.
2021.
Bradley, do you recall the question?
I recall the question, and I can't tell you accurately whether or not they were in a relationship at the time. You asked me about him bringing me a contract. I said he did bring me a contract, and that is accurate.
Do you remember knowing Ms. Willis prior to her taking office as the DA?
I had very little contact with Miss Willis. I knew her through my business of coming down to Fulton, if that's what you're asking. Yes,
You knew her through the business. So you had met her prior to your contract?
I'm going to object to relevance at this point as to why we're here today.
Sure.
Judge, he doesn't remember much of anything right now. And so I'm trying to create a timeline to hopefully piece this together.
All right. Well, I'm not seeing really the likelihood that that's going to have any success. I'll let you ask a
Exactly.
few more questions, but if he doesn't have a date, then I don't know that you're going to be able to create one today.
Okay, thank you.
Exactly. Like he keeps belaboring this point, trying to get him to admit that, okay, well, did it start on this day? Okay, well, if you received this contract on this day, did the relationship start then? He does not know. He's not going to give you an answer, Ms. Merchant. He is not. His answer is going to be, I don't remember, I don't know, I don't recall. You move on to the next questions. I know she's trying to get her questions in there, but at this point, you have to know when to pivot and move on to your next point.
So the time that you had this contract from January 2021 until January 2022, did you come in and out of the DA's office?
yes,
Okay. And so were you able to witness Mr. Wade and Ms. Willis interact during that time?
I'm going to object. This has been asked and answered. It was addressed at the last hearing about Mr. Bradley's access to and from a specific room to pick up files. And Mr. Bradley said that
Sure.
he rarely saw them together, but this was
Yeah,
Andrew.
I think the only avenue that was closed at the last hearing was his personal knowledge, potentially through, well, actually, no, if he testified, it was that he had no personal knowledge. It's knowledge that conveyed to him that was cut off at the last hearing. That's really the only thing we hadn't been able to explore, unless you correct me if I'm wrong,
Knowledge that was conveyed to him by,
by somebody else. That's that he claimed at the time was privilege. I found that it's not. That's what we're here to explore.
um, do you remember telling me that not many people knew where they met?
I'm going to object as to relevance, as to his personal knowledge, which is what 602 requires.
Yeah, I mean, we're back to the same point, Ms. Merchant.
His personal knowledge is what I'm asking him what he told me.
But he hasn't yet told you how he knows that. And so unless you can establish why he should be testifying on this at all, then there's no relevance.
And I don't know how he knows that. That would
Then
be the
ask
next,
him.
but that would be the next question.
Then
But
ask him how he knows it.
I first have to establish that he said that.
No, you don't. You could go the other way around.
When you told me that
So here we go. The judge. So people have questions like, is it normal for a judge to coach or tell the defense attorney or prosecutor how to better answer or ask their questions? The answer is absolutely yes, it is. I mean, judges are there for many reasons, but one of those reasons is courtroom efficiency. And if the judge kind of sees you struggling, straggling, and you're belaboring this point, or you're trying to get to this certain avenue, and everybody in the courtroom knows the avenue you're trying to get to, but you're struggling to get there, the judge is going to be like, ask the question like this. Ask it this way. You know, this is how you get to where you're trying to go, because we're not going to spend 45 more minutes on you on this particular point because you're struggling, straggling, trying to ask this question. Not that I'm saying Miss Merchant is struggling, straggling, but I mean, it is dragging on here. I think she's trying to really beat an answer out of this man that she's not going to get. So, I mean, I think everybody's frustrated that she's still on this point. She spent, I don't even know, 10, 15, 20 minutes at this point on this particular question. And we still don't know how he knows this information, if he has any direct knowledge, who told him. And that's where we need to get to. We need to get to the meat and potatoes.
it started, when she left the DA's office and was a judge in South Fulton. Where did you gain that knowledge from?
I don't remember.
Well, I'm going to object because his testimony a few minutes ago that he did not recall making that statement.
I'll overrule that. Mr. Bradley, answer the question if you can.
Repeat the question.
When you told me that their relationship started when she left the DA's office and was a judge in South Fulton, where did you obtain that knowledge from?
I was speculating. I didn't have a, no one told me I was speculating.
No one told you that?
No one told me that.
You were speculating based on things that had been told to you or things you had observed?
So I'm going to object as to the nature of this line of questioning because the witness has made it clear he was speculating as to how or what he knew. And if it's speculation, it's inadmissible before this court.
All right, but the motivations for his reason for speculating would be admissible, so I'll overrule that.
Thank you, Judge.
Hmm.
Was this speculation
Okay.
when you told me that?
So what just happened was he answered, I was speculating whenever their relationship started or whenever they were dating, or even if they were dating, he was speculating. Speculation is not allowed in court, but what the judge is saying there is your motivations, your reasons for speculation are allowed in court. And so the defense attorney is going to be allowed to explore the reason that he was speculating about the relationship beginning. So hopefully we hear an answer now, or we're going to get another, I don't recall, I don't know, I don't remember.
Was that based on things that had been told to you and things that you had witnessed?
I never witnessed anything. So, it was speculation. I can't tell you anything specific, if that's what you're asking.
Tell me anything specific as to why you speculated about that?
Yeah, this was however many years ago. I mean, I don't recall, but no, I don't.
Did you have any reason why?
I don't know if speculation is lying, but
Well, let me just show me where in this text it says you're speculating. Or
you didn't ask me if I was speculating or guessing.
I didn't ask you, but tell me if it says anywhere here that
No,
this is
it-
speculation.
If this is the same one that you just showed me, it does not.
And you're welcome if you need to look at your text. Is there any
So she's trying to impeach him at this point, make him look like a liar, make him look like he's not credible. So she's bringing the text message and saying, okay, well, where did you tell me in this text message that you were speculating? If I'm texting you back and forth and we're gossiping, I'm not going to use the phrase, I'm just speculating here, unless I think you're trying to set me up, you know what I'm saying, for court, and I have to make my intentions clear that I don't know what you're talking about. I am just speculating rather, and I don't have any direct personal knowledge. But when you're just talking to somebody on your day-to-day, you're not going to put in the text message, I'm just speculating. Even if you are speculating and gossiping, most people when they gossip are not spelling it out. This is just gossip. So I understand and appreciate what she's trying to do here, but it's not giving the oomph that I believe she thinks that it's giving.
Anywhere in here that indicates that you didn't have knowledge of the
No.
relationship.
Your Honor, I'm going to object. The line of questioning Your Honor directed counsel to explore is where he got the knowledge. She's explored that. He said it's speculation and he didn't get it from any source other than his own speculation.
Sure.
So
I think we're fleshing that out, and I think it's her right to have a little leeway on this if he's an adverse witness.
Thank you, Judge. And Judge, these speaking objections are clearly coaching the witness because he's regurgitating.
Your Honor, I
What-
object and take offense to that comment. I'm objecting based on the law.
So now the defense attorney is saying that the speaking objections are clearly coaching the witness. So she's saying that every time the prosecutor gets up and objects, that he's actually giving a clue, a hint to what the witness should say. So if the prosecutor gets up and he says speculation, and then the witness says, I don't know, I was just speculating, right? She's saying that the prosecution is sending clues to the witness in order to avoid the questions or get out of it. And so now we're going to hear back and forth about, the prosecutor saying, well, I'm not coaching the witness. I'm saying objections. And I don't know what else you want me to do. That's my job, is to say objections according to the law. And so there's a little accusation going on here by the defense attorney towards the prosecutor.
And I'm making a record for the court.
All right.
So I take offense to that comment. It's not the case.
All right. Well, I think we can start with objection, the grounds, and the rule number, and then if I need more, I'll ask.
Thank you.
All right.
Thank you. What did Nathan tell you about the relationship?
Objection, hearsay.
Nathan has testified. It's not
Yeah.
hearsay.
It's still hearsay. It's an out-of-court statement being brought in for the truth of the matter asserted. So hearsay.
Judge,
Yeah, this would be for impeachment by contradiction, which would
Thank
be an
you.
exception to the hearsay rule, and admissible as substantive evidence, and the privilege issues are overruled.
thank you, Judge.
So the prosecutor objected to hearsay. Say it's an out-of-court statement used to prove the truth of the matter asserted, and it is hearsay, but there's an exception to hearsay, which here the judge stated that it's allowed. It's a hearsay exception because it's impeachment by contradiction. So that's going to be allowed. The testimony, the statement, whatever, it's going to be allowed in court. So yes, hearsay is always going to be an objection when you hear an out-of-court statement, but it's going to be on you, the defense attorney, 9 times out of 10, to explain why a hearsay objection, why a hearsay exception rather stands there, and why you can get that statement in.
Issues are overruled.
Thank you, Judge.
Well, I think he just overruled the privilege objection, but we don't know when he's talking about. So we've already established the December
Right.
2018 privilege.
Sure. And that's something I covered in the in-camera hearing, and I'm, based on what he told me in that in-camera hearing, I don't believe any statements to this effect were covered by privilege.
And Judge, I just want for the record, because sometimes the record doesn't reflect where people are looking, and that when I ask a question, Mr. Bradley is looking at Mr. Wade and his lawyer to wait for them to object, and they're clearly interacting somehow in the court. So I just want the record to reflect that, because it wouldn't otherwise.
It's there now.
Thank you.
Do you have a question was put to you, Mr. Bradley?
Judge, one of my lawyers is sitting right in the back.
We
That's
don't have to go
behind.
down that rabbit hole. You can look wherever you want.
Yeah, and I'd never looked at Mr. Wade or his attorneys. That sounds true.
All right. Mr. Bradley, question was put to you.
So the defense attorney again here making another accusation that Mr. Bradley is looking at Mr. Wade, looking at the lawyers, and signaling to them to object before he answers a question, which I actually don't think that's true, because he started answering questions many times and the lawyers have been objecting, but he's still been answering the question at the same time. So for her to say that is, I mean, I understand why she wants to put that on the record if it's true, but she's flinging out lots of accusations are being thrown around here.
Repeat the question, please.
Yes. So I showed you, or I asked you, I'm sorry, the last question I asked you.
And I will say too, the judge was like, you can look wherever you want. I mean, he didn't really scold Mr. Bradley, because I don't know that she even has enough evidence to claim that, but she wants to put that on the record for the appeal, for another court to look at, so that they can read that and think, oh, well, maybe he was being coached.
Was what did Nathan Wade tell you about the relationship?
Objection, Your Honor.
And that's already been ruled upon.
I recall him stating that at some point they were dating. I can't tell you what date that was. It was made in confidence. We were in the back of our office. Our offices were the only two in the back. There was no one else present. That is all I can tell you at this time.
One time?
One time.
You only had a conversation with him one time about the relationship?
Objection, asked and answered.
No, I think that's a clarify for their own sitting cross. Ms. Merchant.
I do not recall any other time that he mentioned that they were in a relationship. No.
You may not. He ruled that he was.
Congratulations.
Okay.
Still on the record.
So you talked about this one time, and you said you don't know when it was though, correct?
That is correct.
Was it before Mr. Wade, before you got the contract in Fulton County? Let's start with that.
I do not recall.
And how did it come up?
Say again.
How did it come up?
I do not recall how it came up. It was in the back. I know where it occurred. In our offices in the back. I can't tell you what we were discussing prior to that.
Okay.
Did you receive an email from me on January 6th with a motion attached?
I think I did. Yes. Yes. I know. I received I don't know if the date is January 6th, but yes, I received that.
Okay.
Yes.
So you remember receiving that?
Yes.
With the date. And you reviewed it, and then you and I spoke about it. Do you recall that?
Did we speak over the phone or are you saying through a text?
So this is going to be important because she's talking about the motion, the disqualification motion. Essentially, this was the start of the disqualification whole big to-do, right? So she sent him actually a copy of the motion. And from what I understand, he reviewed and read that motion, gave her advice on what to add in that motion, how to make it stronger, how to make it better. And for him now to be a witness in that motion in the case is wild, but that's essentially what she's talking about. So it's going to be important to flesh this out. So I want everybody to listen closely here.
That's what I'm asking you.
I can't remember whether it was text to phone or
But you recall us speaking one way or another.
one way or another. Yes.
And where I was trying to confirm the facts in that filing.
I think I remember there was a line about the accuracy of how much money that my office, the law office of Terrence Bradley, have received, and whether or not that was going to be in the motion or not.
There wasn't a discrepancy. I had kept that out. You asked me to step back in, correct?
I recall you that may be accurate. Yes.
And you thought, because you thought it might be suspicious if you were left out of the motion.
No, I think we discussed that it should reflect the accuracy because the accuracy was that I received, I had a contract and received 74,000. And I think you had put in there that Mr. Campbell had received a certain amount, and then you also had put in there that Mr. Wade had received a certain amount, but there was not anything in there originally. And I said that it needed to be accurate. I needed to be accurate as far as that I had received 74,000. That's correct.
Because you did not want anyone knowing that you had talked to me.
I'm gonna object this to relevance.
Be biased. Overruled.
What? So, all right. So she's asking him, okay, so originally she didn't have anything about Terrence Bradley in the motion about how much money he made, the contract that he received from Fulton County. He's saying he received $74,000. He read the contract, and from what I understand, was saying, no, you should put something in there about how much money I received, so it should be accurate. And then she followed up saying, because you didn't want anyone to know that you had talked to me, and I'm not sure where that's coming from.
I wanted you to be accurate as far as the accuracy of our message or your filing.
Okay, so that was your interest was in accuracy in the filing.
I didn't reach out to you and say, send me a copy of your motion.
Right.
I didn't reach out to you to say that I'm going to be in your motion.
Right. I asked you to review it for accuracy.
For
right?
accuracy. And I just stated that it was inaccurate.
And the inaccuracy that you pointed out was the thing about or how much you had made.
That was the inaccuracy that I saw that jumped out, was the fact that I saw that I was left out.
So she's probably trying to pin down, okay, I gave you the motion, you reviewed the motion, and I asked you to review it for accuracy. And the only thing you reviewed and the only error that you noted was the fact that I left out how much money you made in the contract. You didn't say anything about the relationship timeline being inaccurate. You didn't say anything about all these other inaccuracies if they were inaccuracies, right? But now you're coming and you're saying that what I wrote in the motion or the relationship timeline, everything I said in that motion is incorrect, it's inaccurate, or you don't remember. So why didn't you say that at the time? Why didn't you say when I sent you the motion that the relationship stuff is not true, it's inaccurate? You didn't say anything about that. So she's trying to say that because he did not say anything about those other facts being inaccurate, right? The relationship facts being inaccurate, those facts are in fact accurate. And he is now not telling the truth on the stand.
When you had put
Okay.
the firm, the money was, I did not, when I responded to that, it was for that specific reason.
And I agreed I would put that back in, that section back in, and I
Correct.
did. I did put it back in and I sent it to you again.
I don't recall getting a second email from you, no.
But you were happy that I put it back in, or that I agreed to put it back in.
And object this to relevance.
Yeah, when you get to more material aspects.
Yes, Judge, I'm moving along, I promise.
Then move, sister.
So you did ask me to put that back in.
Again,
Well,
asked and answered relevance.
well, he didn't answer that last question, so overruled.
You did, can you confirm you did ask me to put that back in for it to be accurate?
Yes, that's correct. I said that, yes.
And then I asked you if everything was accurate and you said, looks good,
Ooh.
correct?
I recall you asking that, but the looks good was applying to the
Yeah, so this is actually a really good line of questioning, and I wish he had gotten here earlier instead of wasting all the time on the personal knowledge that he did not have about the relationship, whether he did or he didn't. Obviously, she believes that he did. See, this is good because now we can say, okay, you had this motion and it was alleging all these facts about the relationship, the trips, the timeline, and you didn't say anything. I think this is an excellent line of questioning because she's also pointing out here that he said looks good, right? Looks good means looks good. The motion looks good. Everything I said in the motion is correct to your understanding, including the relationship stuff. And he's, of course, clarifying, well, no, you're mischaracterizing what I said. I didn't say looks good as to the entire motion. I said looks good with respect to the accuracy in regards to the payments received by myself and to his knowledge, to his colleagues, if he had information and knowledge about that. So here we have one example of two different viewpoints on one conversation. And that's a hiccup. That's a conflict that we see a lot in this particular case with this witness and this defense attorney.
accuracy of the 74,000. That's it.
So when you reviewed the motion and you specifically pointed out that one thing that you found inaccurate, you didn't point anything else out that you found inaccurate in that motion though, correct?
No, I did not.
And that motion alleged that their relationship began when Ms. Willis was in municipal court.
If I can reread the motion, but I don't recall, but if that's what it says. But I did my saying that it looks good was when you put back in the 74,000 into your motion.
Okay, and that wasn't what I was asking. What I was asking is, you didn't tell me that there was anything else inaccurate in the motion though, right?
But I didn't state that anything was accurate other than the 74,000.
Now, when I told you that I had this motion that I was preparing, you asked me to send a rough draft.
No, that's incorrect.
May I approach, Judge?
You may.
Here we go. So he's saying that's not correct. Here we're going to have another, probably one conversation, two opposing viewpoints on the conversation. And I will say it does seem like the defense attorney here might be mischaracterizing the testimony, mischaracterizing what happened, right? She's saying, well, you said everything was accurate. He's saying, well, I didn't say everything was accurate. And who knows, though, maybe she did take that to mean accurate, like the whole motion was accurate with respect to the relationship timeline as well. And maybe he did have a different viewpoint. I don't know, but I do see the argument on both sides.
Page are you showing him?
They're not page numbered. It's January 6th.
I just see it.
Yeah, of course. I can show you if you saw the text.
I don't have pages.
Look and see if Mr. Precision reading. So, we had been talking and you asked me to send you a rough draft and I told you, okay, but I didn't want it to be leaked before I filed it. Right?
That is correct. That is correct.
So you're the one that asked me to send a rough draft.
Yes, that's correct. Yes, that's correct.
That was at 10:08 on Saturday, January 6th.
Okay, so he got into this mess because a few questions ago he was like, "Well, I didn't ask you to send me a draft of the original motion. I didn't ask you to, reach out to you and tell you to send it to me so I can review it for accuracy." And then come to find out, when she filed the motion, right before she did file the motion for real, he did ask to see a rough draft. So I don't know why he even brought up the rough draft thing, that he didn't ask for a rough draft, if knowing all the while that later on he would ask for a rough draft. So that's kind of, it's a little bit of a gotcha moment, I think, right here, that it opened the door for her to be like, "Oh, you want to talk about rough drafts?" So I'm not sure why he even brought that in.
And then you got an email from me with that rough draft at 10:25 that same day, correct?
Yes.
If you need to look at it,
If it says 10:25, then I know you sent me an email.
While he's looking at it, I'm going to object us to ask and answer. We've been through the fact that she sent him a copy of the motion, whether he specifically said rough draft or not, and then asked about the accuracy. He's explained his answer, and I've to ask and answer. So
Understood, Mr. Vaughn. We're getting there. Overruled for now.
and then I responded when we were talking about that footnote that we were just talking about. I said, I took it out, but I can add it back. And you said, yes, add it back. You remember that?
I answered that yes.
And then I said, anything else, anything that isn't accurate. And you responded, looks good. You recall that?
Let me see the.
And there, I don't know where the exhibits are. They were admitted.
I mean, again, at this point, we get it. You know what I'm saying? He didn't say, he didn't point out the inaccuracies about anything else aside from the money. We get it. I don't know. I feel like she can move on from this point. Like, she's already laid the foundation, made the argument. We understand. Move on to the next point. I think I don't know if she's just trying to make a record. I mean, obviously, she's a very skilled, experienced attorney. I do think this is dragging on a bit much, though.
That refresh my mind?
It says looks good, but as I stated before, I was responding to you putting me back into the motion for receiving $74,000 in a contract.
This says, you said, yes, add it back. And then I said, anything else, anything that isn't accurate. And you responded, looks good. So you weren't responding to put it back in.
and I'm going to object.
I
This is
know.
not his motion. He wasn't the affiant of the motion. Verified.
Overruled, Mr. Body.
Talking about personal knowledge.
I've said
Okay, so then she clarified. I said if there's anything else that's inaccurate, and you said looks good. So I mean, again, I understand her position here.
it
Personal knowledge.
twice.
Overruled, Mr. Body.
I've said twice that the looks accurate was, or I've said more than twice, was for the 74,000.
Do you remember telling me about Nathan and Fani coming to your office and spending time together at your office?
No, I mentioned, I do recall testifying on the 16th that she had come to our office.
And that was before she was elected as district attorney, correct?
I recall that was when she was district attorney. Because I said that there was a meeting held at my office.
And who was at that meeting?
Now, I can't tell you that. I don't recall.
But you know, Ms. Willis was there, Mr. Wade was there.
It was at our,
So I understand what she's trying to establish here, right? But Fani Willis and Nathan Wade have already both agreed that they knew each other prior to him working at the district attorney's office. And they had met probably for the first time some point at that conference. So I mean, I know she's going to have to raise the inference that they were together at his office in a romantic way, but I don't know if that's what's proven here, right? Because we knew already that they knew each other.
office. Actually, Miss Willis was there and there were other people there. Mr. Wade was not in that meeting. He was in the back. I wasn't even in that meeting.
Why did she hold it at your office then?
I have no idea.
You also remember telling me about them spending time together at her law office before she took her job.
I don't recall. Do you? I don't recall. Do you have something to?
Well, what I'm asking is, so let's back up a sec. So Ms. Willis rented a law office from the Evans firm, or Andrew Evans and another lawyer, I think Stacy Evans. You have knowledge of that, correct?
I'm going to object to hearsay.
If
Well,
How does he know the information? That would be the correct question.
Okay.
How would he know who she? I mean, yeah, I don't.
Ms. Merchant?
I don't really know even how to respond to that. Hearsay. I'm asking if he knew that she rented
Yeah,
offices.
he may have been there. He may
Right.
have seen a business card or something at some point. I think you can answer that.
I've never been to Miss Willis's office when she was in private practice. I've never dealt with where she rented. I didn't even know where her office was. So
Do you remember though, knowing that she rented an office?
yes,
From the Evans?
yes,
You did know
yes,
that.
that,
Thank
that
you.
is correct. Yes.
Okay.
Oh, okay.
And do you remember telling me that Mr. Wade and Miss Willis would rendezvous at that office?
I'm gonna object to, again, hearsay as to how he knows that information. He said he has no personal knowledge. And
He did
just-
not say he has no personal knowledge, Judge. He hasn't even answered it.
No, he said in general, he had no personal knowledge. So it's not been established the source of how he would know this because he said he's never been to her office.
All right. Ms. Merchant, if you, I know you're trying to impeach him by a prior inconsistent statement, but unless you can first back up and show why each statement is actually something that he had knowledge of, I don't know if this is going to be relevant.
Something that he had knowledge of and something that's relevant, right? I mean, he said he's never been to her office. He doesn't. He said also though that he did know that, or he thought that Fani Willis was renting the office from the Evans people. Again, I think she's gonna have to tie this into, okay, why is this relevant? What are you really trying to ask? No, she's trying to impeach him and make him look like a liar. But again, she's having to get here through hearsay, because that's what this is. It started off as gossip, right? And so she's always going to consistently run into these hearsay objections. And she's done, I think, a decent job of getting through the exceptions to the hearsay, right, objection. But I just, again, we're running in circles here.
And Judge, I'm not even there yet, but again, that a speaking objection. And so now I would anticipate what our response is going to be next. I didn't ask anything that was objectionable, but these objections are coaching the witness. I asked if he had knowledge. That's it. I didn't ask, did someone say this to you? I didn't ask, what did this person tell you? I asked if he knew.
Well, no, you're asking if you had knowledge and then you say of something specific. So,
Once I get an answer to that, if he has knowledge, then I will follow up with where that knowledge came
all
from.
right, well, let's try again.
So my question is, do you have knowledge of them meeting at that office?
Objection, foundation.
Okay, all right, overruled.
Do you have knowledge of them meeting at that office?
I have no personal knowledge if that's what you're asking.
I didn't ask that yet. I asked if you have any knowledge.
Objection, that would be hearsay.
Overruled.
Not if it came from
We
Mr.
don't
Wade,
know where it
Judge.
came from. So he said, how do you know, Mr. Bradley?
How do you know?
Any knowledge that I would have received would have come from my client at the time.
Okay, so you had knowledge of this place that Miss Willis worked. What did you know about them meeting at that office?
Objection, hearsay.
It's not hearsay,
Overruled.
Judge.
How he knows it, and then you ask the next question.
All right, he's already asked the next question.
Can you repeat the question?
Yes. How do you have knowledge? What knowledge? Well, you just told us. You told us Mr. Wade told you. So tell us what Mr. Wade told you about Miss Willis and Mr. Wade meeting at the Evans office.
Objection, Your Honor, privilege. This clearly covers the time after December 2018 that would be covered by the privilege.
Yeah, overruled.
The judge has already said that he doesn't find the information to be privileged. So I think the defense attorney has done a good job, right? She finally got past all those. There was a flurry of objections by the state: privilege, hearsay, foundation, whatever. But now we're here, and he's going to have to answer, how did he have that knowledge? If he was told that, he said any knowledge he had was from his client, Mr. Wade. Okay, so now let's get into it. What did he tell you? How did he tell you? Where were you? Did he also tell you about the relationship? Again, I don't think she's going to get very far with this, but I think she has finally gotten to the point where it's like, okay, he knew that Fani Willis was renting this office because he heard that from Mr. Wade. And why would they be talking about that? Her inference is it's because they were in some sort of relationship, and that's why they were sharing these details. Again, I do think that's a little bit of a stretch, but I think she's allowed to certainly make that inference and make that argument.
Do you recall the question, Mr. Bradley?
I do not.
You can re-ask the question, Ms. Merchant.
What did you learn from Mr. Wade? Because I was clarified that's where you learned it from. About Mr. Wade and Miss Willis meeting at the Evans office together.
I don't object to ask and answer. He's testified that.
He hasn't answered. We haven't heard an answer.
Yo, okay, state y'all OD at this point. Like, yes, I understand they're trying to get the person, not even their guy, right? But they're trying to get this witness to not answer any incriminating questions about Fani Willis, who they're representing. But at this point, like, it's OD. You gotta let the defense attorney. It's getting frustrating for everybody, I think, at this point. And the judge is like, "What are y'all doing?" At this point, it does seem like you're just obstructing the questions and trying not to let the witness answer and trying to throw everything off and slow everything down. So I get it, but I mean, OD, definitely OD.
He testified he had one conversation with Mr. Wade in the
Yeah.
back of his law
Judge,
office.
Yeah, and his answer may change, so
Still in
overruled.
office, how to answer the question.
That's-
I can't recall what the conversation was. I do recall knowing that he would go down to the office or had been down to the office, but I can't tell you in what capacity or when or any of that. No,
Mr. Wade told you that they had sex at the office, is that correct?
I don't recall him stating that. No.
What? Where's she getting that from? So she just asked, Mr. Wade told you that they had sex at the office. So that's at the Evans office. I don't know if she's pulling this out of thin air. I don't know if somebody else told her this. I certainly knew that he was not about to answer. Yes, certainly I knew they had sexual intercourse at the office. I think this is a good stopping point right here. This testimony is 2 hours long. We're about now at the 1 hour. If you need any help with your criminal cases, please contact me below. In the description box is my information. We also do car accidents and trucking accidents. And we're going to pick up on part 2 in the next video. Thank y'all for being here. Don't forget to hit that like and subscribe button, and I will talk to y'all